Any mention? Item number 1.
Only one matter, no? What is it? What report?
Maybe, please, Your Lordship. I have procured a medical status report. Your Lordship was pleased to send for medical examination of the convict. And Your Lordship will see that in the medical report, the last page by Dr. Hammer, B.R. Dakar, in the last page of the medical report, opinion and recommendation they have given.
Where is that?
Lordship has got a last page of the medical report.
Oh. Oh, this one we've seen earlier. Yeah.
Yes. No psychiatric symptoms seen at present from MSc. From history, there was an abnormal behavior years ago. Exact history is not known. To do a psychological assessment at Civil Hospital Shillong and to get more reliable information for detailed history if available. Then it was referred to, this was on 13/11/24. Then it came to Your Lordship, Civil Hospital on 18/11.
Where is that?
On 18/11/24, in the report, Civil Hospital report, Lordship got that?
Where is that? Yes.
Then Meghalaya Institute of Mental Health, Neurological says,
Yes.
refer to CHS for psychological assessment, Your Lordship.
History of mental illness, years ago, not available. Yes, exactly. Yes.
Then intelligence skill, the last test finding, Your Lordship, on Whistler Adult Intelligence Scale 4,
Where are you reading from?
the Psychiatry Department, Civil Hospital Shillong, 18/11/24, Lordship.
Yes.
That type copy.
Yes.
Dr. Srimati Parriott, E. Parriott. The client attained a full-length intelligence quotient of 67, which is indicative of mild intellectual disability. So this mild intellectual disability, Your Lordship, I am trying to do some research work on that, and Your Lordship still yet to find out many things.
See, Mr. Mahanta, why is the court concerned? Because you had reported that
Yes.
he was having some
mental disorder.
Yes,
He was taken to MIHAMS also.
Thing is that, you see, now what we are just inquiring is what is his mental condition now.
Yes.
Now, how can we ascertain whether, because trial's over, now you're on appeal here.
That time,
what was his mental condition at the time when the trial was taking place, where he was fit to stand trial? Not that inquiry was never done by the
never done by the court nor the
he
council.
Was and there was no medical examination with regard to his mental faculties or condition, right?
Yes.
That's the only thing that, you know.
In fact, Your Lordship, just for, since the mild intellectual disability.
What is mild on, what is Westler Adult Intelligence Scale?
Mild intellectual disability. Under one copy. Your Lordship, just Your Lordship, the Indian laws, Your Lordship, unsound mind in Indian law, the Indian Penal Code Section 4 states nothing is an offence which is done by a person unsound mind, Your Lordship. The second paragraph, the term unsound mind is not limited to mental illness but also includes conditions like mental retardation or intellectual disability. So, this mild intellectual disability, whether it comes under unsound mind or not.
What is this Westler Adult Intelligence Scale for? Because I'm impression on Westler Adult Intelligence Scale 4, the client attained a full-length intelligence quotient of 67, which is indicative of mild intellectual disability. Mild intellectual disability.
That is nothing but IQ test, my lord. It's IQ test.
There is also unsoundness of mind. It comes IQ test. Below 70%, that is Mildly.
Then you have to show some authorities on that.
Yes, yes. No, therefore I'm trying to procure.
Intelligence scale.
Yes.
If they are below some
Lordship,
certain score,
I'm trying to procure
then
some more.
Maybe they're not,
Yes.
And what was the mental condition at the time of
at the
trial?
time? Correct. So now to go back there.
Now he's charged with how many co-accused are there?
No, only he himself.
Only
himself. And it's a peculiar case, Your Lordship. What happened? The MDC took him when he came up from the cultivation. He saw that so many people gathered. MDC saw him, pick him up to Joy from Sampung, asked him to sleep with his son in the night time. Then next morning after breakfast, took him to the police station, said to the police that you do whatever you like to do. Last night there was a double murder in our village. I brought this man, and no FIR has been given. And on that basis, a GR case was registered. And what happened? 2-3 days they were never produced before the court. So later, when the family men were inquired, the loss of this man, then said he put it in the police station. Then they came to know he is arrested. But in fact, he is innocent. Maybe the MDC took the advantage that of unsoundness of mind that better put him there. And he was never inquired. He was never given any statement before the police, the MDC. So this is the reason that the suspicion comes that why it had happened like that. So, and apart from that, the many interesting things that IO said in the evidence, I never examined any witness. Then how come 2 witnesses came back?
At the time of this arrest, what was his age?
Was the case, if Your Lordship is pleased to turn to page page 2 of my paper book, Your Lordship will see. Page 2, date of occurrence 14/5/92. 14/5/92, Your Lordship. Then Your Lordship will come to the page 7. Page 7, Your Lordship. FIR number 69/5/92, dated 25/92.
Out of 6 days.
From 14/5 till 25/92, there is no FIR.
That's all right.
Yes.
I mean, that is.
Yes, Your Lordship. Then, Your Lordship will see date of arrest. They have shown 15/5/92, the next day, in page 8, date of arrest. At serial number 13. Now, Your Lordship, page 16 is the case diary. From page 16, Your Lordship will find how the accused has been roped in. Page 16.
Mr. Mahanta, there's the medical report at time of arrest is there. Medical report of the accused.
No medical examination not there. That is the surprising part. Your Lordship will see, page 16 is the GD, extract case of GD.
No,
And
as per page 16,
16.
extract copy of July page 19 now it says that so-and-so MDC appeared and produced a following accused person reported the accused committed double
reported
murder.
the accused person committed a double murder on the night of so-and-so.
So that means that the MDC only facilitated the
MDC, he brought him.
Yes.
The accused was kept for interrogation in connection with the murder case, kept at the police lockup for safe custody after bodily charge, so-and-so message O.C. Rillian for necessary action. So this is the basis of his arrest. And
now the people who were murdered, their family members.
Family member, they say. Family member. But from the family member, there is no FIR. Nothing. And no one came forward to give evidence also. And there is no statement number 161 of the family member of those PW 1 and 2.
What is the relation to the deceased? What is the relation? I mean, they were family members, but what is the exact relation between the deceased and these accused?
That is, means within the same family, they say. Huh? Same clan. The same clan.
There was no Ejhar, no GD entry is treated as FIR only.
Yes. And even Mr. Sulet also never examined. Neither by the police as 161 or by the court. Of course, now he is no more. Then why the suspicion comes, Your Lordship?
Now, who are the prosecution witness?
Prosecution witness 1 and 2, one is the wife and another is the sister. I'll come, before I come to prosecution witness, Your Lordship, I would, page 42, the PW6, this is the IO. Page 42, PW6. Lordship got that. May I be permitted to read? Your Lordship, I joined the service on oath. I joined the service in 1990 as Sub-Inspector of Police and posted at Juai S12, Giant Hills District till 1992. That I am the IO of the case endorsed to me by the OC Juai PS, Inspector So-and-so Khongla. It was GT entry number 500, dated 15/5/92. That GT entry I read, Your Honor. And on the basis of GT entry, I was endorsed to investigate the matter. On being endorsed with the investigation, I proceeded on 16/5/1992 night. 14 is the occurrence, Your Lordship. 15 guns, 16/5/1992.
So that means he did inquest at that time?
Yes.
Inquest was done on 16th?
16. That's what the surprise. How can it be?
14th. Anyway.
Anyway, Your Lordship will see. To the place where the so-and-so, Sangpong, in the compound of the murder disease, late so-and-so, there were 2 dead bodies, one of Srimati so-and-so and Lo Rabon in the compound. I have held inquest on both the dead bodies, which were identifying by the family members of the deceased. That means 2 days the bodies were lying there. Your Lordship. The bodies were lying on the ground covered with a shawl. Exhibit 1 and Exhibit 2 are the inquest report prepared by me, and Exhibit 1 by 1 are my 2 by 2.
There was no ocular evidence.
No. Those 2 witnesses came to give the ocular evidence, poses to be the sister. One is a wife and another is sister. Nowhere their names in the church sheet also. Nothing. Then Your Lordship will see, next paragraph, that dead bodies were sent for the postmortem to Civil Hospital Joy, and I returned back to the PS, and the next day I was transferred to headquarters at Shillong. This is very important. I have not examined any witness in this case. This is the IO. He has not examined. Even the other IO, subsequent, he is the IO to give the charge sheet only. He also said, he didn't examine any witnesses. He forwarded the charge sheet. Then the cross comes. The date of the occurrence was 14/5/92, and the incident took place at the PO. When I proceeded to PO on 16/5/92, the dead bodies were still lying in the compound. The dead bodies were sent for the post-mortem on 16/5/92 night only. I have noticed cut injuries on the both the heads of the disease. Is a fact that I have not reflected the cut injuries in the inquest report prepared by me in respect of so-and-so. That much of the IO. apart from that, Your Lordship, what is happening is a very peculiar thing in the judgment. The entire judgment is based on the case diary. Section 172, subsection 2 of the CRPC says, Your Lordship, case diary cannot be used as an evidence. If I'm permitted to read 172, subsection 2, any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diary not as evidence in the case, but to aid it in such inquiry or trial. So prejudice has been caused, great prejudice has been caused. On this ground alone, the whole case goes. 172, Your Lordship got that? It cannot be used as evidence, and there are category of decisions to that effect.
Okay. So, firstly, Mrs. Manta, we'll do one thing, then we'll proceed with the hearing, because mild intellectual disability, I don't think it will.
No, this is unsigned. It is unsigned. But anyhow, I'll place that, Your Lordship. There's some.
You should have done some more, some more research whether.
No.
But other readers were concerned that at point of time, when he was tried, whether 313 statement I saw is denied.
No, this is the problem. Now, last time also, I have been appointed as an amicus curiae by the court at July to assist in with regard to insanity and unsigned. Then a lot of research has been done. I have given all the decision of the Supreme Court, different high courts, and all this I have submitted to the court also. In mostly July, this type of cases are always going on. So it is duty cast upon the trial judge to see whether accused is capable of understanding the charges, or whether
what is the assessment and has to be done, whether that, and even the motive. And
those has to be looked into. But a trial court, they never look into all these things. Just that a case comes, then Your Lordship, whatever case appointed, some they appoint State Defence Counsel, good case to cross, decline cross. It happens. So that way a lot of prejudice has been caused, Your Lordship.
Last order. What is she doing? What is she doing? Yes, for which did I order? Yes. 13 to 1024. This is 13 to 25.
First time we see you for something.
411, right? So what type can you receive copy 32 can you get it? To mark it. Can you 13? What type can look, careful about this 3024. As directed by this court, in terms of order date 4/11/2024, copy of the medical reports on the medical status of the appellant had been supplied to the counsel for both the parties. Stop. Next paragraph. Today, Mr. S.P. Mantha, senior counsel, assisted by so and so, has submitted that it is apparent, or it is seen that that the report the report uh, of the psychological tests conducted at Civil Hospital Shillong has revealed that the appellant has mild intellectual disability. He submits that he prays that he be allowed to some time to ascertain as to whether this would be an impediment to the conduct of proceedings. Stop. Mr. Garu, what did you say? Mr. Al Gurung also, our prosecutor appearing for the public prosecutor, has submitted that some research is required to ascertain the correct picture. Stop. Accordingly, it's a matter 2 weeks enough. Otherwise, if this multi or this ASLA, whatever,
Yes, sir,
motion
2 weeks,
67, if it does not,
Yes, sir,
if there's no impediment, then we'll go ahead and hear the
Yes,
matter.
we'll go ahead.
And if, from what we gather, it's very sketchy. Very sketchy. Even if we've done it,
I mean, the law points also.
because one thing, Mr. Mahanta, also you brought up, when was this appeal filed? In 21.
21.
The first time you brought it,
3 years. Sir. 3 years. Sir.
after 3 years, the matter was pending, then he brought up that
I know.
he is, like his relative said, he's unsound.
Yes.
My lord, I have not started, my lord. Let my senior finish. I'm fully ready with my lord to explain as to the insanity, my lord.
No,
I have
with
done
regard to
my
merit of the
extensive
case, I am
research, my
still
lord.
ready. Now also I am ready with merit of the case. But only
After
that
orders
part.
been passed, you said you're ready then.
That apart, my lord, the paper book, my lord. Now, my senior had just submitted that no medical was done, my lord. It cannot be believed, my lord. By no stretch of imagination, my lord. That report, my lord, is in the trial court record, my lord. That is
It's not in the paper book.
It's not in the paper book.
Then that is
It has to be incorporated, my lord.
No, if it is there, then
trial
I'll
court records are here.
also check it again. I'll check
You
it.
kindly check it.
I'll check it.
Any mention?
It is Lordship. Lordship, I pray your Lordship indulgence to have the item number 32 to have this matter after.
Upgrading.
Yes, keep it to Lordship hearing.
Two? What do you want? What? Adjournment?
Yes, Lordship. It's hearing, Lordship.
No urgency.
No urgency.
2 weeks. Yes.
Much blessed, Lordship.
Have you seen them?
Number 26, madam. They've come out with the rules. They've given a copy. It's not.
Which rules?
So the education department, Lordship will recall these matters related to promotion.
New rules now?
My lords, yes. New
Frame when?
January
2025. 17 January 25.
Even we are not aware of the rules.
The Lordship will recall I pointed out that there was a committee. We just found out on the last date, my lords. So I've shared a copy.
How does it impact the case?
But I just received it, I'll go through it, whether it's beneficial to
Because
us or
there's a
it's against
savings
us.
provision as well. So we'll just see how they are impacted. Even we'll examine it, my lord.
Yeah, Dr. Enmozi, Leonard Counsel for the petition counsel, so that they are just in receipt of the newly framed rules,
Gotcha.
which have been supplied by the common advocate. He plays for how much time?
2 weeks.
2 weeks time to study the same. Yes.
Obliged, lord.
Item number 27, Lordship, on behalf of A.H. Caravan. Respondent number 2 and 3.
Where is Kharwanlang?
In this post, Lordship.
In this post?
Your Lordship, for the petitioner?
You have no objection?
No objection, Your Lordship.
2 weeks, okay.
Much obliged.
Lordship, I beg to mention item number 33 from the main list, Lordship. Lordship, I'm praying for 1 week's time, Lordship.
Yes.
My lord, no objection.
1 week, yes.
Please, my lords, I beg to mention item number 31. We had sought for instructions. We are still awaiting the clarifications, my lord.
What's the matter about?
It's regarding payment salary, Lordship.
Okay, 2 weeks, yes.
2 weeks, my lords. Obliged.
Right, Lordship.
Your Lordship, I beg to mention item number 30.
Number?
30, Your Lordship. Your
30.
Lordship, yes, Your Lordship.
Why?
Your Lordship, I'm praying for 2 weeks' time, Your Lordship.
You. Yes, who's up here with
My
respondent?
lord, I'm for the state respondents.
Your objection?
No, my lord, we do not have.
Your objection?
Judgment of Supreme Court.
18 years?
My lord, diploma.
MTT.
Diploma, my lord.
Is connected at
My lord, it will
is
be.
connected to Istiar columns.
My lord, yes.
Then, where's the senior?
Your Lordship,
Where's the senior?
he's not feeling well, Your Lordship.
Okay. Yes.
Much obliged, Your Lordship.
Your Lordship, I beg to mention item number 34, Your Lordship. Your Lordship, I'm praying for 1 week time, Your Lordship.
No objection, Lordship.
Very good, yes. 1 week.
Obliged, Your Lordship.
Yes.
Lordship, I would like to mention item number 29. The conducting...
Who's for the appellant? Yes.
3 weeks' time, Your Lordship.
Why?
Conducting counsel is not keeping well, Your Lordship.
Who's another counsel?
BD Kanwar.
BD Kumar.
BD Kumar. He's another counsel. He's busy all over the country. Yes.
Well,
No urgency.
there's an interim order in our favor.
Okay, 3 weeks at the request of
Respondent.
you are sorry.
Your name.
Arpol.
On behalf of Mr. B. Kumar, senior advocate, who said to be not available today. Yes. Yes.
Watch out, please.
Supplementary list item number 1.
His Lordship. Lordship, this is the contempt petition, Your Lordship.
I think this is number 1 you've given is, I think this person's retired, if I'm not wrong.
I will try to find out, Lordship.
Mr. P.D. Sama, please will to ascertain the status of the respondents as stated, to obtain settlement inasmuch as he said the respondent might have retired since yes.
Much plus, Lordship.
Just after 1 week.
Lordship.
You'll find out.
Item number 2.
Well, please, Your Lordship. Lordship, this is a pension matter, my lord. Here, the petitioner retired in the year 31st, on 31st/3/2023, my lord.
23, yes, then?
Yes. Thereafter, his pension and terminal benefits has not been processed till date, my lord. And he has suffered a stroke. He's in a dire situation, my lord.
In which department?
Secretariat, my lord. GAD department. And moreover, my lord.
So what's the reason they've given you for not processing his pension?
They said that the respond number 7, my lord, has filed an application before the district council, my lord.
District council?
Yes.
Number
for
7,
enhancement of the maintenance amount, my lord. For that
number
reason.
Number 7 is Accountant General.
Oh, respond number 8, my lord. Sorry.
Surprise.
Respond number 8, my lord.
Yes. And okay, heard Mr. A.G. Mohan issue notice. That means there's a dispute between you and 8.
Yes, my lord.
That's held up everything, yes. Mr. A.
One
Mohan
to
is present on behalf of respondents number
1 to 6.
1 to 6. Mr. K. Kaufalang is present with file number 7, so no notice required any further respondents. Please take steps for service of notice on file number 8 within 3 days, list after 2 weeks.
Item number 3.
Lord, similar matters have been filed, my lord.
What is this matter?
Lord, the petitioner has since retired in September 2023, but there are pending issues, my lord, which have to be resolved. Now, my lord, the petitioner entered service in 1993. If your lordships kindly have page 21.
Flip now. 21.
Page 21, next to one, my lord.
Yes.
So this is the appointment letter, my lord, dated 6th of August 1993. Now, my lord,
where's his name?
Yes, I'll just take your lordship's his name, but prior to that, I'll just read the first paragraph, my lord. Because there was a selection process, my lord. There was an advertisement in Dongmusa. He applied for it. He was a technical person, and he was appointed after due process, my lord. Subject to discharge without notice and without assigning any reasons thereof, and also subject to satisfaction and PVR, the following successful candidates, my lord.
This is what level? Grade 4?
My lord, these are technicians, yes, my lord, grade 3, lab technicians, as recommended by the departmental selection committee. So, my lord, there was a selection process. Now, subsequent to that, my lord, what has happened is, he was also confirmed in service, my lord, at page 33. Annexure 6. Before that, I'll just show his name in the selection list at page 24. Serial number 46.
Okay.
Serial number 46 is the petitioner, my lord. Now, at page 33, he was confirmed in service, my lord.
By the competent authority?
By the competent authority, my lord, appointing authority.
Page 33.
Page 33, serial number 1. My lord, pursuant to that, my lord, in the process of regularizing the services of the employees of the government, my lord, at page 34, this is the cabinet approval, my lord.
Yes.
For regularization. Now, pursuant to that, my lord, at page 36, this is in March 2023. Again, my lord, it reads, in pursuant to cabinet approval dated so-and-so, OM number so-and-so, on completion of special interview conducted by the Departmental Selection Committee. Now, my lord, in 93, he took part in the Departmental Selection Committee.
Again?
My lord, these employees were asked to, my lord. He had to take part.
He is a different footing.
Yes, my lord, exactly.
Just serving ad hoc.
Exactly, my lord, exactly.
He was selected, he's confirmed.
Yes,
and then he's reconfirmed again by
yes,
this cabinet.
Yes, my lord. Now, my lord,
There are similar cases. How does the government deal with this kind of thing? Because some cases, I remember, they've been confirmed in service, and then their name comes out here again. Then they have the problem of prospective, retrospective regularization.
Yes, your lordship. So, your lordship, I need instruction. Notice my bishop.
Now, my lord, what happens is, I retire.
Pensionary benefits.
I retire in 2023, my lord, and then comes page 39.
Yes.
So, page 39, my lord, the Office of the Accountant General has returned my service book, my lord.
Why?
Because, my lord, in between, upon being confirmed, he was also receiving his ACPS. So, his pay was at a higher level, my lord, last pay. Now, they say, my lord, at para 2, as per para...
However, retired income, okay, yes. As per para, read.
Yes, as per para 1 and para 2 of an exchequer of Government of Meghalaya, a finance department, white OM, dated 30th of September 2011, it is stated a financial upgradation under ACPS is admissible to an employee on completion of 24 years of service to be counted from the date of entry into regular service and ad hoc service, though allowed to count for increments, pension, etc., will not be counted for the purpose of financial upgradation on ACPS. Similar at para 4. However, if the retired incumbent is entitled to ACPS and specific approval orders for the finance department needs to be furnished in this matter, and on receipt of the said approval orders so-and-so forwarded to this office along with pension paper, service book so-and-so. Further, in case of MACP is eligible to incumbent, the effective date of granting MACP needs to be reviewed, copy of the order along with an extra needs to be furnished. Now, pursuant to this, my lord, an order has been passed at page, which is impugned, my lord, at page 44. This is issued by the Joint Secretary, Health Department to the DHS, my lord. And my lord, in the second paragraph, it reads, my lord, in view of the above, kindly take necessary action in correcting the same and avoid complication on pension papers. So, my lord, this is what I'm seeking a stay on, my lord, because, my lord...
But this is 27 October 24. How can I ask for stay now?
No, your lordship.
My lord, this copy has not been marked to me. I have just obtained it, my lord.
So, your lordship, I need instruction. 2 weeks time I be given. Because so many annexes, your lordship.
I'll just take your lordships to one clarification by the finance department at page 31. This is in 2014. This is a clarification given by the finance department to the DHS, my lord. This is dated 3rd of December 2024, page 31.
Yeah.
It reads, my lord, subject is clarification on assured career progressive scheme. I am directed to refer to your letter cited above relating to ACPS and to furnish the following clarification. Number 1 is very important, my lord. An employee who has been confirmed in the post is a substantive holder of the post. In other words, he is a permanent employee of the government, irrespective of whether his service has been regularized or not. Therefore, the length of service should be counted from the date of initial appointment. So, this is the clarification given by the finance department.
Okay. But Mr. Philonombi, if you notice, Ms. Shaji, the on behalf of all the respondents from this call for, there's a 2 instructions affidavit, yes.
May I please, your lordship?
Let's stay on the impugned order, my lord, because correction
after,
means, my lord...
Accountant General may be mid party in this error is respondent number 6.
Action on the part of respondents will be subject to further orders of this court.
Deeply obliged.
Yes, why don't you implead the AG also?
My lord, here the government has to clean its house, my lord. Look, connected matters coming up on 2nd of April. There are a batch of matters.
Similar footing.
Different, my lord. This is retired, those are not retired.
List on 2nd April.
Yes.
Item number 4.
This other matters on 2nd April.
Item number 4.
His Lordship. Lordship, this is the here the petitioner is a spokesperson who represents the state on the 37 national game Goa, which was here on the spokesperson. Spokesperson. He represents the state. Yes.
He represents the state.
Yes, he represents the state. On
in which sport?
It's a golf.
Golf.
Yes. Yes, Lordship. Now, what happened, Your Lordship, in this case?
What's his handicap?
No, he's not a handicap.
So, handicap in golf is like how good is a golfer?
Yes.
What's his handicap? Yes, okay.
Handicap is not handicap, my lord.
Yes. Yes, okay.
Yes, in the case, what happened is this MPSC, they have given the invited advertisement on 8 March 2024 for various posts, whereby the petitioner here is apply for the post of research assistant under planning department. That is page 19, that number 4, my lord. Now that post, that vacant post, total number of vacant posts was given, 5 vacant posts.
Where is that?
Yes, that is page 19, my lord. Page 19, serial number 4. Serial number 4.
Okay.
It says that research assistant under planning department. Now total number vacant of posts is Kashi Jantia 1 spokesperson, then Garu 2 posts, that is inclusive 1 spokesperson, my lord. Now the petitioner have participated and he was given a call letter. He has participated and after getting the call letter admission, he has participated in the screening test and he has applied also. And thereafter, the result of the interview, they have declared. May I just
only an interview?
Yes, I have given a written exam. Examination.
Pass the written exam.
That pass, Your Lordship. I'll come to that now. Page 32. Now what happened? That my case is now.
No. Now he passed or not? Did he sit for the examination?
He is for examination.
Then what happened?
Then they said that
he didn't qualify for it.
They don't mention the qualify, but they said there was no candidate for the post of spokesperson from Garu community. That thing was mentioned. Now in this case, out of 5 posts, 4 person is already declared as a declared. Now the 1 vacant post reserved for the Garu spokesperson, that is still undeclared. Because they in that, may I take you to the page 32, my lord. Page 32. they have mentioned that there was no. May I just read the observation to which page 32. This is the notification dated 27 February 2025. There are 4 persons actually. Doctor posts are 5, but now here declared 4 persons. That is from Kasi Jantia.
No, he didn't qualify, that means.
But they have mentioned here there was no
candidate for the post.
Yes.
There was candidate for the post means that after results of the interview, now there was a written test. Where is that? Where in the advertisement? Let's see. What does it say?
Yes, Lord.
That's page 20.
My calling letter, my lord, is page 28. This 20? Is my call letter.
20?
Page 28, Annex 3. There's this is the admit card, the call letter. They have given this, the subject is given General English 50 marks.
That means you didn't pass the written test, you not called.
Lordship, now may I take you to the Annex 32, not Annex 32, Annex 35, my lord. In this particular
Annex 35.
Yes, Annex page 35. I'm sorry, page 35. Now here they have not given a cut-off mark for Garu spokesperson. They have given only the cut-off mark.
See.
Yes, Lordship.
How do you spell mark sheet?
This is the mark sheet, my lord.
How do you spell mark sheet?
96.
How do you spell mark sheet? See from the type copy of the original. How do you spell mark sheet? You know. You're really careful with your spelling also.
Oh yes, some.
Yes. See, he scored only 96 out of 322. Where's the qualifying marks given here? Where's the advertisement? Let's see. Where's that advertisement you showed?
It's page 18, my lord. It start from page 18, and then
18.
Yes, it start from page 18 till
okay.
Page 18 to page 25 till 25. Here,
this is
page 24. They have given the general English, general knowledge. At page 24, they have mentioned. They have not.
Now, sports person, only those who have represented the state at the international, national, regional level in disciplines listed in Olympics is considered a sports person. Is golf an Olympics?
Yes.
Golf an Olympic sport?
Yes, Lordship. That certificate, page 37.
No, it's Olympic sport. Golf?
No, Olympic, yes. National. Indian Olympic Association, yes, national game represented.
Whatever it is, it says that sports person only those who have presented the state at the international in discipline listed in Olympics. Is listed in Olympics as a sport, golf. Any idea? Golf is listed in Olympics.
No, whether national game is Olympic or not.
No, he's taken part in national games. This is 2023. I think you failed the written test, that's why.
But your lordship, the
application 50% in all these written tests. Anyway,
it appears, it appears, your lordship, that he got a score of 96 mark only, whereas the cutoff mark is 124, your lordship.
Where you get that cutoff?
Lordship will.
But the cutoff was not given to.
Lordship will find that.
No, that is only for Kasi Gentia, not for Garu sports
That will
person.
be applicable, your lordship.
It is very clearly mentioned in the page 35. They have given a cutoff mark.
Page 35,
there's no cutoff mark for Garu sports person. In the down the line, they
lordship,
have
that is within the box.
Garu 176.
Garu 176.
Yes.
Then SC, then the 152.
Yes.
Kasi Gentia sports person 124.
Yes.
Then there is no.
So 176 is for you. You got 96. More for higher than for Kasi Gentia. See how?
No.
Garu mark unreserved 208. Garu 176.
Yes.
OST other civil trade 152.
Kasi Gentia?
Oh yes. So you failed.
Here they have not mentioned Garu sports person.
They said Garu cut off. What doesn't mean that you have to say Garu sports person cut off. What do you want to do?
And then in the advertisement, my lord, they have.
No, see, that don't go to advertisement now.
No.
I was looking for this reason. Yes. Mr. Shulai has shown it. Yes, cut off is 152. The total marks is 322. Correct?
Yes. He got 96. He got 96
total
only.
marks is how much for the written papers?
He got 96, lordship.
Lordship, they are, you see, General English 50, marks,
lordship, that
50, mathematics 200, total 300 marks. 300. That means you have to score at least above 50%.
Page 24, your lordship, for research assistant. General English 50, general knowledge and aptitude 50, economics, mathematics, statistics 200 marks.
Your golf will help you in this mathematics and statistics. That's all. What are you going to do?
Your lordship will withdraw, your lordship.
You withdraw. You take instructions.
Yes,
you tell your prepare your golfer for the bad news. See, they didn't pass the exam, so what to do?
Yes, Lordship.
Yes, Mr. P. Sangma, after hearing some please able to obtain instruction. This is matter after 1 week. Yes.
Lordship.
On Monday, they 24 days.
Apply, Lordship.
Item number 5.
I didn't see that cut off. Yes, was there.
Lordship.
My lord, item number 5 to 9. Right? Item number 5 to 8, my lord, are these similar matters, my lord. The issue in this case is, my lord, is quite similar to one of the issue, my lord, that came before this honorable court, then the Guwahati High Court, my lord, in the Shillong bench, my lord, in the case of Bornot Rambai, my lord, my lord may recollect Bornot Rambai, where my lord was counsel. In that case, my lord, in this,
so you plan to use a judgment to influence the court.
my lord, it's very much similar, my lord.
I don't record at all. So should I aware or judgment?
No, Lordship. Let
Bornot Rambai.
share and me that judgment.
Yes. Here, the issue is this, my lord. We were regularized.
1 second. (2005).
2004, 2005, my lord.
Lordship, this is a pre-Uma Devi decision, Your Lordship.
So should I appear there also for the state?
I was there, Your Lord.
So,
Lordship was the petition.
So the concern was that.
The operative part.
Yes.
Para 8.
Yes, ma'am.
Okay, yes, what is the matter?
So, my lord, here also, my lord, we were regularized, my lord. We were regularized based on the Departmental Selection Committee, my lord. Recommendation of the Departmental Selection Committee, and our services were regularized, my lord. And having been regularized, my lord.
What level post? Grade 4 post?
Grade 4, my lord.
Then
Grade
how
4.
can they regularize from departmental?
My lord, director is the head of the directorate, my lord.
He's a competent authority.
Yes, he's a competent authority, my lord. So initially, what happened? How did we enter into the service is because for this particular person and for all the others also, my lord, my father was working in the department. The department concerned is the Food, Civil Supplies and Consumer Affairs, my lord. So my father was working. While he was working in the service, he suffered a stroke, my lord. So thereafter, my lord, I was the only eligible member of the family. So in order to tide up the financial crisis, my lord, I was allowed to officiate. Subsequently, my father succumbed to his stroke, my lord, while still in service, and I was allowed to continue, my lord. And thereafter, my lord, the director, then the matter went to the Departmental Selection Committee's recommendation. There was a meeting, and taking as a special case all of us, because somewhere or the other, our parents, my lord, died while in service, my lord. So, taking into this consideration, our services were regularized. We joined the service, my lord. We joined the service.
But there was no advertisement for these posts.
No advertisement. These are sanctioned posts, no advertisement, my lord. Yeah. So for about 9 months, my lord, we were drawing the salaries. We were paid as a permanent members, my lord, in a pay scale, my lord. Now there comes an impugned order. On the page 15 would be the impugned order, my lord. Page 15, my lord, 15.
15.
15, my lord. So there comes an impugned order. The impugned order is passed from the joint secretary, my lord, and directing the director, my lord, directing the director to immediately revoke the regularization order, my lord.
Okay.
So this is so we were aggrieved by this order, my lord, because, my lord, just show me that. Because, my lord, in the first place, my lord, the director is a competent authority, my lord. In order to, because he's a head of the department in the directorate level, my lord, and we are group 4, so he is a competent authority, and there is also, my lord, office memorandum of 1990, my lord, passed by the personal and administrative reforms department, my lord, where
Saying what?
it is saying that because here they say that all this regularization, the MPSC and MPSC is a person is an authority to conduct, but here in this one it says it has given some exemptions, my lord, which process will not come under the purview of the MPSC. So these are the process which comes, and authorizing, empowering the director to appoint, my lord.
Where is that notification?
The notification, my lord, it is office memorandum is here, my lord, 1990 office.
Why
memorandum.
next it here?
My lord,
You're
oversight.
seeking to rely upon it.
Oversight, my lord. I am so sorry, my lord. So these are the basically, my lord.
Yes, Mr. Shulai.
So I'm not aware of that, Your Lordship. It appears, Your Lordship, that the appointment is
irregular
against the constitutional provision, Your Lordship. Article 14-16 not followed, Your Lordship. And
Why
the
you say
record,
that?
Lordship, no advertisement, Your Lordship. Kindly see, Your Lordship, the nature of appointment. Kindly come to page 17, Your Lordship, annexure 3. Is allowed to officiate as DUF 3. Lord, yes. And this is extendable, Your Lordship, after a period of 60 days, Your Lordship.
Okay.
And Lordship, these are the posts, Your Lordship, these are posts which fall within the purview of the district selection committee. So these are required to be advertised, Your Lordship. It has to be.
So that's why this court asking whether the directors, community authority, and they are selected to the departmental selection committee.
Lordship, director will not have
and
that.
Also, number 1, number 2 is. There was no advertisement.
Yes, there's no advertisement.
Lordship, in my humble and respectful submission, Your Lordship, director will not have that authority to regularize, because a regularization will have to go through the.
Mr.
My lord, in the mean,
one thing is that now whatever it is, right or wrong, they've been regularized.
Yes.
Drawing regular.
Lordship, if
but then they've been reverted back to ad hoc now.
Yes.
Because a mistake, if it's detected, it's required to be rectified, Your Lordship.
And let them find affidavit.
Yes, my lord. My lord, in the meantime, my lord, because we are put
no
in
recovery, yes, okay. For time, no recovery from your pay, whatever.
No recovery, my lord. That is, but we.
Are you working or are you out of service?
No, we are working, my lord.
That means they are back to
which post?
Against the same post, my lord, without pay, my lord. And we are not been asked not to come also, my lord. Every day we are getting duties, my lord. And it's been for the past.
This office, which is in Shillong?
Yes, my lord, Shillong. Civil and food supplies, my lord.
How can you see this still working? When was that letter given, and when were you? Where's the order of termination?
No, no, they have not terminated.
Sorry, I mean, where's the order stopping you from, reverting you back to
Your Lordship?
That is only. That's the reason why, my lord, I am praying today, my lord. Let till the pending of this case, my lord. Let the director not act on the directions of the respondent number 2, my lord, the secretary, my lord, the impugned order.
No. Where's that order we say that you've been reverted back to ad hoc?
No, not yet, my lord. It's not been acted.
You're harping on that.
No, we are not harping on that. We are right now, my lord.
By giving this judgment,
yes.
There's a case where they regularized, and then after some time they were reverted back to.
Yes. That's why I said yes, my lord. So that was
casual worker.
That's
not permissible.
Yes, that is why, my lord, I said that it's more or less similar, because my fate is going to be.
Where's the yes to your prayer?
My prayer is page 11, my lord. First is mandamus directing the respondent number 2 to set aside the impugned order, and second issue, read a mandamus restraining the respondent number 3 from acting or taking any action on the order or direction contained in the impugned order.
What is call for this date? Because this, where's that page 15?
Page 15 was passed on 15 July 24, Your Lordship.
That is 15 July 24.
15 July, my lord. Yes, my lord.
Now we are. We open letter counsel as petitioner. You should notice this initial AG with Mr. Also is present, except on behalf of all the respondents of required. These are 2 weeks for instructions affidavit case.
My lord.
Oblige, Your Lordship.
Up to 8, my lord, as a similar matter. 1 to 8. Obliged.
Exactly similar.
Yes, my lord.
Daily list item number 1.
Should have come immediately. Yeah.
May please, Your Lordship. Your Lordship, I'm entering appearance on behalf of respondent number 2, the action committee. Your Lordship, may I be filing the violent amount in the course of the day? Your Lordship, may it allow
So not you file the affidavit? Yes. Then who's appearing for, oh you're here, about 3 is?
I'm for the counsel.
Number 3. Yes. Yes.
Lord, I'd like to draw your Lordship's attention to Section 8 of the 1959 Act. My Lord, here it says that qualification for the office of headman. Pending making of rules as provided in Section 3, the chief and his durbar shall determine the clan or clans that can set up a candidate for the office, the qualifications of a person eligible for the office of a headman, and the manner in which a headman shall be nominated. Now, an appeal against any order passed by the chief and his durbar under subsection 1 shall lie to the executive committee, whose decision shall be filed.
That we last
In fact, my lord, in the first round of litigation, to avoid all this, I had made a submission before your lordship saying that we will conduct the elections. But then
what happened was,
came on appeal.
This thing is that that's why this court took a lot of affront to submissions made by Mr. Nath. Sorry to use the name, but the thing is that they went on appeal, saying that they never made a concession, and if you remember, before this court said we're not in a position to conduct elections. That was a pointed statement, and then that's perjury. And then he went up to the division bench and said that we never made a statement before the single judge. He misconstrued it. We should conduct elections. That's why they're unfit to conduct elections.
That's why, my lord, I also had made the submission saying that let us conduct.
Yes, let us conduct elections under this.
59, but under 59, otherwise, if they are aggrieved, they have to come before the EC.
What about the election? Now it's already been done. The results have been coming.
No, your lordship.
And that's under your custody now.
Yes, your lordship. Even the documents and whatever materials of the office
but
of the
conduct themselves is really it calls for heavy costs to be imposed on Mr. Nath's client. Because firstly, preferring an appeal after making submissions at the bar that we're not in a position to conduct elections, and going appeal and saying that misconstrued, we are ready to conduct elections.
Lordship.
And also, it was sort of pardon but then as if the district council's collusion also with the appellant at that time, and sort of influence the division bench to say, oh yes, then there's nothing to decide. They can hold elections as per 959. Let them hold it, the chief.
Unfortunately.
And then coming around and then like to disqualify a person because he's litigated against, is that a ground for disqualification? Hold elections.
My lord, there is no instance that any litigation has been filed against the Imam by the petitioner.
Very polite, Mr. Nath, the way the case has been conducted. Very polite. This court looks at very polite. Because if once you, as a counsel, so once you make submissions before the court, you expect it is an honorable profession. And honor demands that even if clients advise otherwise, you should go by what, Anyway, where's the affidavit? Mr. Kriam, for whom?
For respondent number 2.
Yes, Mr. Kriam has entered appearance today on behalf of the respondent number
2.
Number 2. We took at that time with urgency.
Yes.
Number 2, election committee. As such, notice complete on all the respondent stuff. Next by Mr. T.D. Rinto, learned senior counsel, appearing house number 3, has submitted that as per the provisions of the Succession of Chiefs Headman Act 1959, any grievance against the orders of the chief is to be first put before the executive committee. Stop. It therefore submits that put it back for the committee. It's a fit case to that the respondent number 3.
The petitioner. Should approach.
The petitioner, yes.
Your Lordship, Your Lordship, in accordance with the affidavit that they have filed by the respondent number 1, they have relied heavily on the court adong. Your Lordship, and claiming that it has been codified by the respondent number 3, the court adong. Lordship, this is the document which they have also
But has
relayed.
it been? But this is custom, correct?
It's just
It's custom, yes.
So the thing is that the condition is there that if you
No, Your Lordship, there's no
the
condition.
problem that you'll be ineligible to contest for the post of headman.
No, Your Lordship, there's no such condition in even of. So, but they impose the impugn terms of condition, Your Lordship. They impose on that condition, which is never present even in the court adong. And this court adong requires examination, Your Lordship, because on basis of this court adong, Your Lordship, which has been relied by the respondent number 1, it has created all havoc and controversy, Your Lordship, within my village. So, Lordship, the crux of the matter is related to election process of the
See,
headman.
the thing is that it can't go without a proper headman also. There has to
Yes.
be a proper election.
Yes, Your
It's
Lordship.
in interest of
That I agree, Your Lordship.
And you two fighting and all will not, solve anything. We'll send it to the council then.
Your Lordship, since
Adong Hima is not recognized.
yes, Your Lordship. And Your Lordship, my nomination as well rejected when we questioned about the terms and conditions was applied. The respondent number 2 state claimed that it has been recognized by the respondent number 3. So whether Your Lordship, because as per Section 21, Your Lordship, of the 59 Act, power to make rules, it needs approval of the Executive Committee of the District Council, Your Lordship. Lordship, the Lingdo respondent 1 is relying heavily on the court adong.
Anyway, we'll send it to respondent number 3. Yes. Give me yes,
We will examine.
Yeah. Yes. In the instant case submits with a dispute regard to the rejection and nomination of the writ petitioner, this instant petition has been filed. Stop. What submission do you have, Mr. Kriyam? Mr. Charnat, yes. On behalf of the respondent number 1, submit that the affidavit has since been filed. Stop. Next paragraph. Having considered the matter on the submissions and perusal materials as placed, it is noted that this instant matter was taken up by this court on 18/2, correct?
Yes, Lord.
2025, in view of the fact that the elections to the post of headman, which link value is sorry? Of Maukhap. Maukhap Krishnong.
Maungap Krishna.
Amount of election was scheduled. Was scheduled on which day?
18.
On 18
18
itself.
February.
And on the ground that irreparable injury would be caused to the writ petitioner who was debarred from contesting the same, this court had passed interim order keeping the election results in seal cover under the custody of the respondent number 3. Next paragraph. Today, as this matter still hangs in the balance and in view of the other developments, this court deems it a fit case to remand the same to be adjudicated by the respondent number 3, bracket executive committee, who shall pass appropriate orders thereon after taking all relevant facts into consideration. So we send a writ petition, or
Your Lordship, a matter of concern.
you file a fresh, one, and then till that date we just
Lordship, matter of concern, Lordship. Number of voters in the village, they have cast their vote.
The writ petitioner therefore directed to approach point number 3 with proper political appeal, and after due notice, the point number 3 shall dispose of the matter in accordance with law. Stop. It is further provided that till further orders are passed by the point number 3, the results of the shall be kept in abeyance.
Lordship, but time frame, Your Lordship, is as of
the notice to appear. You will need to file it
within 1 week.
Yes. The writ petitioner shall file the appeal within a period of 1 week from today, and the parties put to notice to appear a week thereafter.
Highly obliged.
Matter according stands closed disposed.
Item number 2.
May it please your Lordship.
So the appeal decided.
Lordship, it's been reserved, Lordship, as per order dated 6th of March, Lordship.
Reserve.
CAV, Lordship.
What's the matter about?
Lordship, the instant matter is a contempt.
No, I mean, what is the subject matter of the writ?
We're praying for
Regularization?
regularization. Yes, Your Lordship.
Yes?
We are praying for regularization.
Yes, list after, on the request of Ms. N. Nishilav submits that the judgment in appeal has been reserved, listed after
3 weeks, Lordship.
3 weeks.
Item number 3.
Much obliged, Lordship.
Lordship, in this matter, we have already filed a rejoinder, Lordship.
Yes?
I pray that the matter may be listed for hearing, Lordship.
You want to file a joinder?
I've already filed, Lordship.
Your pleadings are complete.
Yes, Lordship.
Complete the pleadings. Complete the pleadings. So parties submit the pleadings complete. MS. Your name, sorry?
JT Sangma, Lordship.
JT Sangma submits that no rejoinder will be necessary. Stop list the matter for hearing also.
Item number 4.
Lordship.
On the last occasion, my Lord has given me last opportunity to file the affidavit, my Lord. But however, I could not file it, my Lord. I'm praying 2 days' time, my Lord, to file the affidavit.
Mr. Chanda asked his last opportunity. Where is Mr. Chanda? All other affidavits have been filed. All have been filed.
violation.
No.
It's the aim of
Filed is whom?
I'm for the respondent number
filed?
5. It's the private respondent, my Lord, who is in the possession of the property, my Lord.
It is a matter for hearing. Respondent number 5 permitted to file rejoinder in the meanwhile. Yes.
Affidavit, my Lord. Affidavit, my Lord. Affidavit in opposition, my Lord.
Right.
Item number 5.
Lordship, private respondent has filed affidavit. Lordship may fix for hearing. Lordship.
You want file rejoinder?
I will.
Yes, MR Marak submits that no rejoinder will be filed by the writ petition. According to this matter for hearing on so and so, yes.
Much obliged.
Item number 6.
My Lord, the state affidavit has been filed this morning, my Lord. I have filed this morning, 1 to 4.
What, number 5?
Number 5 has declined, Lord.
You won't be filing. Yes, Mr.
Well, it's 6
Padilla
and
submits
7.
that he just
We have
received
6 and
a copy
7
of
also.
copy of the affidavit filed by state respondents.
My Lord.
Just for hearing or you want rejoinder?
My lord, respondent number 6 and 7 are Durbashno, my lord, if I humbly submit.
They have not entered appearance after serving of the
been
notice.
served, correct?
Yes.
Because the dispute is between the Durbashno and the petitioner, my lord, more or less.
Oh.
So, my lord.
Who's appearing for Darwasham? You are
No,
appearing
no.
for number
That
5.
is Muda.
Any order passed for ex parte hearing?
Lordship affidavit has been filed, but no order has been passed, giving them an opportunity to appear.
No, affidavit has been filed by whom?
Affidavit is been filed by the petitioner service, and
Mr. Abel submits that the affidavit has been received, or response has been received. However, he also has informed the court that the till date is no appearance or response 6 and 7 spite of service notice. Stop. MSR Kolni, on behalf of the state response, submits that 6 and 7 are vital respondents in view of the fact that the dispute is between the writ petitioner and response number 6 and 7. Stop. Next paragraph. Having considered submissions, though service has already been effected upon 6 and 7, the writ petitioner to take fresh steps.
no, Lordship, already taken fresh step by Dusty also.
Second?
Yes, second time. And for that affidavit had already been filed. Affidavit dated 24th.
Postal also. And in view of the fact that Dusty service also been affected upon response 6 and 7, let the matter proceed ex parte against the said respondents. Stop. On this matter of hearing when?
After 2 weeks, Lordship.
This matter of hearing after 2 weeks.
Item number 7.
Please, Your Lordship. Lordship, in the last occasion, we have apprised this Honorable Court that there are few documents we have sought for.
From the petitioner?
From the petitioner. So they are yet to supply those documents, Your Lordship. So after the documents are sought for supplied to us, then we'll
why not supply the documents?
Your Lordship, we need some more time, Your Lordship, to finish the documents. They have asked for the fresh income certificate also, Your Lordship, so I need some more time. I've applied for the same.
Marbo submits that the writ petitioner has been able to obtain the documents as requested by the respondent. She prays allowed how much more time?
2 weeks, Your Lordship.
2 weeks for a time. Prays allowed just after 2 weeks, yes.
Highly obliged.
Item number 8.
Please, Your Lordships. Well, this is the case where respondents are yet to file their affidavit. And there is an interim order till today, Your Lordship.
Regarding?
This is regarding a boundary dispute, my lord, in 2 villages, which was settled way back in 17. And then, my lord, they approached the tribunal almost after 2 years. So that was rejected. Then they came to the High Court for condonation. Realizing that they will not be successful, they had withdrawn. They filed a suit unsuccessfully, Your Lordships. Thereafter, they again approached the EC. So against the decision of the EC, I have filed this, my lord. Anyway, I let them file the affidavit, Your Lordships. The Lordship can take it up for hearing.
No, I think 6 has been served. Respondent number 6.
That is by whom?
The executive committee had condoned the delay, my lord.
Yes.
In filing of the appeal.
This was filed by you, affidavit today.
My lord.
Who filed it affidavit today?
Yes, my lord. There is regarding, my lord, service on respondent number 8.
1 second.
Okay.
8 is Hima Khairim.
Yes.
6 we have filed caveat, no?
What do you want today?
But they are yet to file the affidavit, Your Lordship.
We are not filing an affidavit.
Court village.
When are you filing?
2 weeks, Lordship.
Till then, that interim.
Tribunal?
This council, we will not be filing.
Yes, Mr. Marpan, the council for number 6. How much time?
2 weeks.
It is for further 2 weeks' time to file the affidavit. Says praise allowed. Stop. Affidavit step. Like for an affidavit indicating service on spot number 8 has also been filed by the petitioner. Stop. Such service complete on the respondents. This after 2 weeks for affidavit or for further orders.
Interim order is there.
Interim order when you continue the next day.
Obliged.
Item number 9.
My Lord, the petitioner last Lok Adalat, National Lok Adalat, he had attended, but it seems they have not reached any. No, it has not reached any settlement.
So what should we do now?
I can proceed. That the respondents file affidavit.
Yes?
That the respondents file affidavit.
Yes,
We can proceed.
office note indicates that the matter, though posted for National Lok Adalat, could not be settled. Next date for what?
For affidavit, my lord.
Yes, accordingly.
I'm for 1 and 2.
You are respondent number? Who's number 4? Of? Of? I can't hear you. Mouth long.
In fact, the real dispute is between the petitioner and number 4.
What's the dispute about?
It's a land dispute. They have taken the land of the petitioner. No, they have taken the land of the petitioner for using for road. Yeah, that path without proper settlement or without giving anything to him. And the district council have passed the order.
This is a fit case for civil suit. How will this court go into all these disputed facts?
My senior rightly said that it's a civil dispute. Therefore, the district council has no authority, no jurisdiction to pass such order, the impugn order, against the petitioner. So we limited prayer here that to vacate that order, to stay that order. No.
You seen the order, Mr. Dingdo? Yes. This was given by the. It's not even as a. It's not even order of the executive committee. Also, it's just. It's not inter-party also. Who brought it before the? You brought it before the district council?
Yes, I brought before the district council.
Hukum generally like that only.
Yes, it's a general. And
yes,
this was
more of an administrative order.
Therefore, we approach
because it's just for what do you call it, so that there won't be any hardship caused. It won't give rise to any law or other situation. But because they're using the road from your land, correct?
Yes. But with this order, Your Honor, I mean, Your Lordship, sorry. Your Lordship, with this order, then the other respondent in the village, they bulldozed me. They just taken my land as they wish. So it should not be like that. Let them, actually, if they are ready to settle, we came last time to settle with them in the national.
Did they appear in Adalat? They came.
As per my instruction, they.
Did you come? Who's there? You were there for the darbar, correct?
I was from the headman.
Did they come for the Lok Adalat? Who's the lead? Who's the lead counsel? Then what happened? What is the objection?
As per the instruction that I received, Your Lordship, they said that they will settle this matter through a proceeding in the Darbar. So we are willing, actually, if they settle proper proceeding by addressing our grievances, even from the side of the respondent number 4. That was instructed to me by the petitioner, and it could not reach settlement.
You see, to subject to civil suit again, it'll take you, and it'll become acrimonious in the thing, and it'll take you years, and it might lead to other situations. The thing is that
we can re-examine the matter, the executive committee.
You have filed affidavit. But today, what is your objection? As per instructions, what is your objection? No. Its objection is that, do you say that's village land, or do you recognize the right of the petitioner over the land which he is using? No. That means recognize that the land which that road you're using goes across the petitioner's land. That you accept. Correct? You say, why you say no? You said just now, give his own free will. Free will, that means his free will is his land to give. So what is the stand of the Darbar? Does it recognize the petitioner's right over the land? That it belonged to him, and that the people have been using it for many years to go by to use that path. What are your instructions? We is the only one who's here before us. The other ones are given free will that we're not concerned about. Do you recognize the right of the petitioner over the land? Since given free will, that means his. Correct. Free will is not in total alienation. It means just for use. Correct. Now his grievance is that you're widening the road.
Widen the road.
To make it motorable or something like that.
Yes. Without properly settled with me.
What instructions? You suppose comes like you say, you file affidavit. Where's the affidavit? These matters settle here and now. You call a headman on next date.
Next date.
You call him. Let him appear personally. Also the landowner. Yes, take down. Mr. Passenger behalf number 4 placed well out. Or this matter was placed for the but how it's going to be settled? Stop. It appears that the dispute is with the use of a path 9 feet width and 124 meters in distance by the village people. By dispute, which is stated to be within the land of the writ petitioner. Stop. As the matter affects the community and as the stand of the headman is not clear. Stop. It is directed that the headman of which village is this? Mouthklong, Mensang village, as also the writ petitioner, appear before this court on. We'll give you some time. Maybe by the time you can resolve your appeal this court on 3rd April 2025 at 10:30 a.m. List the condi and so on. Yes.
Item number 10.
You can't say we'll hammer out a settlement. Otherwise, you don't have instructions also.
My lord, this matter was on the last occasion was placed before the Lok Adalat, my lord. There are some deliberation from the parties, my lord.
Yes, some?
This matter was on the last occasion, my lord. It was placed before the Lok Adalat.
Okay, what happened?
And parties, they came together, my lord. So there are some deliberations, my lord.
So according to my instruction is that the Darbar said that they will convene a meeting, Lordship, calling together the parties.
What's the matter? Same road?
No, Lordship, this matter is pertaining to that bar license.
Lifting.
Cancellation of the NOC by the respondent number 6, Lordship, for obtaining the bar license to operate a bar.
You are agreeable to let him have bar license now?
Lordship.
You are agreeable to let him have his bar license?
No,
Lordship. Sorry, your
license was already granted, my lord. They need to obtain lift, my lord. That NOC was cancelled by the Darbar, my lord.
It was issued initially. Later on, he cancelled it.
No, who's paying for it now? You. So I agreeable to let him have the bar license after you granted it to him. I mean NOC and took it back. We're not because of a letter. You've taken a considered decision with Darbar to allow the writ petitioner to serve whatever and to get a bar license, correct? And then you turn around and took it back.
My lord, NOC was issued, my lord. On the basis of the NOC, license was already granted to them, my lord. And they needed now the lifting permit, my lord, to lift the liquor.
Where, from the central bond warehouse?
Yes, my lord. So,
okay.
I've been
because
paying
of the law and
rent
order situations, my
monthly,
lord.
Lordship. I've been paying the rent monthly, Lordship.
So that's your own risk and cost.
My lord, we have received the instruction, my lord. We will file our affidavit also.
Where's this place?
Nongthoma.
Ambience.
Lordship.
The matter, though placed for the Lok Adalat, could not be resolved. Stop. MS Bisun on behalf of the respondent number 6. Please for further time to. Please for further 1 week's time to file the affidavit. What about Mr. Sankon? You file?
My lord, 1 to 5 will be filing, my lord.
Mr. Sankon 1 to 5 so submits that. I will be filed within 1 week. Yes. This thereafter for further orders.
Obliged.
Item 11.
Your Lordship, I'm praying for some time to file our affidavit.
Why since last year, the writ petition?
December.
What's the matter about?
Your Lordship, this is termination of service consequent of a disciplinary proceeding, Your Lordship.
Police?
Police, Your Lordship.
Okay, as paid for the 2 weeks time allowed by affidavit, this thereafter also.
Obliged, Your Lordship.
Item number 12.
These are the matters that would
12
be
to
connected
12
with
to 17.
Item, yeah, the main matter would be item 35, my lords, which is on board before my lords.
How long is it going to take? 5-10 minutes?
Take about an hour, my lords. I have to deal with. So I've seen the arguments that have been made by.
No, but only one thing, Mr. Paul, you have to understand that substantive arguments have been.
I've seen the, my lords. I've seen the argument. I am a little differently situated, my lords.
To supplement any other added
My lords,
points.
only thing is that I am a little differently situated than what was argued by Mr. Tiwari insofar as, my lords, the subsequent matter is concerned. Because the genesis of this entire dispute begins with this writ petition which is pending before your lordships.
The BIA?
My lords. So, my lords, certain arguments which were there subsequent in those that other matter, my lords, may not be available in my matter. And I would be a little differently situated than those matters, my lords. To that extent, I would have to deal with the matter.
Subsequent matter hearing given. We just finish the orders first, the other orders, then we'll take up your
Balance.
matter.
Balance.
Eighteen. 18.
What I understand, the matter can be disposed of, my lord, in terms of the last order.
May it please your lordship. Your lordship, what had happened is that after the order dated 1702, I was contacted by the representative of the respondent number 1, who is the PRO. There was a joint inspection conducted on the land, and to that effect, flagpoles were erected at the Mowbray's lordship. So, lordship, that there was at the beginning there was dumping, but then after that, your lordship, the dumping has stopped. Yes, your lordship. So the Mowbrays are preserved.
We'll continue to observe that, my lord.
Mr. LCM, legal counsel, the petitioner, has submitted at the outset that pursuant to order dated 7/2/2025, flag marks have been made.
Have been erected, lordship.
Where the Mowbrays exist.
Yes, your lordship.
And also dumping has since ceased. Mr. Dr. Mozika, also Rule 3, has supported the submission and submits that dumping shall not be, further dumping shall not be done in these areas, and the Mowbrays will be preserved.
Lordship, there's one more development which had happened, is that one of the Mowbrays, which is the last Mowbray, your lordship, after a joint inspection, it was discovered that it was along the newly constructed road, your lordship. So if 3 weeks be given prior notice to the to the petitioner before any works could be started there, so that they can gather the clans, your lordship.
Coordinate with the department. I don't think any order is required.
And the respondent number 3 shall what should he say? Shall ensure that the construction does not disturb
the Mowbrays, your lordship, erected poles.
Any other reliefs on a grievance that might exist, the writ pressures at deputy to approach respondent number 3 for resolution of the same. So, on these submissions, the matter stands closed and disposed of.
Highly obliged.
19.
Your Lordship, we have already taken steps upon the respondent number 5, Your Lordship.
Respondent number 5 was supposed to do the appearance, Your Lordship.
Supposed to do the appearance today?
Yes.
You don't see anybody?
Yes, sir. Lordship. And for the respondent number 1 to 4, Your Lordship.
Yes, when you're not filing affidavit.
Yes, Your Lordship. 2 weeks' time.
Yes, obviously indicates that notice is not complete. It's not as that indicates that respondent has not been served as yet. Top MSSD Sangma, the respondent 1 to 4, please for order. How much time?
3 weeks, Your Lordship.
Yes, just after 2 weeks for affidavit for service report on respondent number 5.
Item 20.
Lordship, in this case, we require some more time, Your Lordship, to file an affidavit. This is a matter where the petitioner has prayed that the age bar may be extended.
That is not the prayer, my lord. The prayer is that the rules, my lord,
whether applicable or not,
yes,
to college,
applicable, yes.
to deficit colleges.
They have no rules of their own, Your Lordship,
What
the college.
rules of their own?
So the rules of the higher and technical education
are applied.
So we'd like to file some, get some further instructions and then file an affidavit, Your Lordship. That is the college.
So you're not sure which rules apply?
I'm awaiting instructions.
You file an affidavit, but this is an important point to
Because
decide.
that is what he's asked for. That
Yes,
his
MST
age
Yangi
is rejected because of his age.
Please, if you have to file an affidavit to put on record the correct position with regard to applicability of rules.
The applicability of the
Similar
rules.
frame made by Mr. M. Kharab on number 6. This after 2 weeks for affidavit.
21.
My lord, item number 21 is connected with 25. In 25, affidavit has been filed, state, my lord. In 21, my lord, I'm praying for 1 or 2 days time, my lord. Affidavit is ready.
No. What are you talking about? I don't know. What's the matter about?
My lord, this is with regard to the medical students' allotment, my lord.
They're all studying now, correct? Yes. They all been admitted.
Yes.
So what remains for us to decide?
My lord, here, my lord, in the particular item number 21, my lord, we are yet to file our affidavit. I'm praying for 1 or 2 days
Why?
time, my lord.
Do we need an affidavit or might can be closed?
Actually, my lord, we have already filed our affidavit in 25. That is the lead matter.
That'll serve the purpose.
That should serve the purpose, my lord. But then we are ready with the
Yes.
affidavit.
My lord, I'm
Yes, 20%.
Oh, sir.
Ready to matter?
Lord, I'm trying it on Monday,
Monday.
next Monday. Next Monday. Next week.
Next Monday means 24th.
My lord.
21, but 21 counter is yet to be filed, my lord. So,
Yes, then Applicant General submits that the counter in
and NMC is a necessary party, my lord, because NMC or MARB.
But had it been implemented, National Mental
The MARB is a party, my lord, because MARB or they are autonomous boards, my lord, autonomous boards, and the autonomous boards are regulating. And so far as graduate is concerned, there is a graduate board, my lord. That board is probably not implemented because NMC is basically a policy making body, but they are being regulated. Give me the
Yeah, number 2. Yeah.
NMC is not the is a separate entity, my lord, and the autonomous boards are also separate entity. So, and so far as graduate is concerned, my lord, graduate autonomous boards are being regulated, so they have to implement graduate autonomous board. And board is the main authority, my lord.
What's this board? You're for the petitioner.
I'm for the petitioner.
Mr.
I appear for the petitioner.
Yeah, you've heard submission to the Advocate General
Yes,
regarding the
yes,
implement of the
boss.
board.
The
Yes.
National- No,
Yes.
The National Medical Commission represented by the Secretary, my lords, would suffice. He will represent all the boards as well.
No, board is separate under section 15. Board is a separate
It is
entity.
under NMC, my lord. It is under NMC. Any directions issued to NMC would necessarily bind.
It is not binding. They are all statutory bodies.
We're not going to go into that. I mean, if a registration becomes disabled because of non-implement, then so be it. Anyway, Mr. Advocate General prays for further 1 week's time to file affidavit on behalf of the respondents number
3, 4, and 5.
3, 4, and 5. The others are all filed. This matter together
3,
with
4, 5, and there is no affidavit by NMC, my lord. NMC is still.
5, 6, 7.
it is noted that it's been served NMC.
My lord, it has been said.
Yeah, though it's 1 over 2 has been served, There's no appearance. Who's appearing for them? No appearances yet. No any affidavit file. This matter after 2 weeks for.
Address is also not come. Address is also not there, my lord. NMC's address is also they have not filed. Proper address.
Yes,
is,
you try to get the correct address. Otherwise, take fresh steps on number 2.
Yes. Thus the at least because NMC is most important party is NMC, my lord.
Those served has not entered appearance. It's been served.
My lord.
This appearance nor any affidavit file. Stop. The learned counsel for the petitioner therefore directed to take fresh steps by thus deemed necessary, as the NMC is a crucial party in the proceedings. Stop. This after 2 weeks for the orders. Yes. We take steps.
Please.
22.
22, 23 and 24. These 3 matters are connected, my lord.
Where's Mr. Changraiso?
Lordship, he has some difficulty, Lordship.
Next round?
He has some difficulty, Lordship, today.
He's not in court.
Lordship, he was in court, Lordship, but he has left, Lordship. Lordship, here the state has to file the affidavit, Lordship.
Where's my affidavit here?
We have filed the affidavit, my lord.
Lordship, they have filed only with respect to 24, Lordship.
24 and in 22 and 23, my lord, the grievances are against the private respondents that their BA degree is not proper, they have not passed.
So those cases die.
No, Lordship, then
those are against first and then
So 22.
Lordship,
File affidavit.
they have to reply, Lordship. They
Because
have to
first
say
we
that on what grounds, Lordship, they have accepted their certificate.
Because
Who hasn't filed affidavit 22?
8 to 17, my lord, respond number 8 to 17 are private parties and their appointment is under challenge, my lord.
They have not filed affidavit.
They have not.
Same
Not in,
respondents.
no, they are different respondents.
Different respondents.
Different.
No, who's the pending for 8 to 17 and this 22?
22.
Who's the pending for 8 to 17?
Lordship,
Item number 23, I'll enter appearance on behalf of respondent number 8, 9.
Oh, no. See, last orders that service report is 17.
Lordship, I've already
filed.
I have already filed the service affidavit, Lordship, today morning.
But almost noting says that it's not served.
It is
Lordship, with
filed
respect
today
to
morning only, ma'am.
item number 23, Lordship. It's already filed, Lordship.
This is 22.
No. Lordship. This 22, they have already appeared, Lordship. This,
No?
There will be nobody in appeal.
445, no. No, but there's certain 444. Lordship, we have filed the service affidavit, Lordship, today morning.
In 22?
We have filed for 22. Yeah. No, but the orders,
Order said is noted that the service report on respondent is yet to be received.
Yes. MS Hajong, you filed which item?
23.
23.
The same respondent.
The same respondent.
Then they've served 23, not served 22.
No, they are not same.
Different respondent.
Different respondents.
Different.
Yes, in item number 23 and 22, different respondents. 22.
Then?
On grounds of challenge are also different, my lord. That's why 2 separate petitions has been filed.
Yes, officer indicates that notice on respondents number 8 to 17 is yet to service is yet to be effected. Stop. Mr. T. Dakhar, legal counsel petitioner, prays that he may be allowed to ascertain the status and to file service affidavit in this regard. Stop. Then next one, 23.
23,
Lordship, is already appearing, Lordship.
Entering my appearance on behalf of respondent 8, 9, 10, 11, 12, 14 and 16, Lordship.
23, Lordship, by challenging the certificates of those private respondents.
Enter with today. I-23. 20. Yes. So these one who MSM Hajong file means they are being
Yes,
instructed
Lordship.
by Mr. Sheikh today. Correct?
Item number 23, Lordship.
Or not correct?
In item 23. In item 23, Lordship.
Okay.
Item 23.
Similar matters creates problems.
Yes.
Yes.
And different payers, my lord.
Mr. S.A. Sheikh today has entered appearance on behalf of, you give the numbers again?
8, 9, 10, 11, 12.
Yes. Stop. It's
14 and
noted that a service affidavit indicating service upon the respondents. You don't know the numbers. 7 to 18.
7 to 18.
It's already also been filed by the writ petitioner. As such, notice is complete on all the private respondents. Who wants to file affidavit here?
Lordship, the private respondents has to file, and also
time to file affidavit. Other affidavits, Mr. Chanda. This matter up to 2 weeks. Then 24.
24 hearings.
Yes. As the other connected
Already
matters are posted after 2 weeks.
Lordship, the state
together.
hasn't filed, Lordship, in this item. Item number 23, Lordship, the state also has to
23,
file.
I will file, my lord, what they have asked for. They are saying that 2 years diploma given by Assam government institution is wrong, illegal. And so and Assam government is also party to it, and private respondents. So private respondents, because whether the institution is recognized by or not recognized, those facts will come from the affidavit of Assam government and private respondent, my lord. As per our record, its degree is recognized, my lord.
Let them file the affidavit.
Let the private parties and Assam government file the affidavit based
Who
on.
was Assam government? Highly confusing.
I say respondent Assam is my lord part. Assam government is respondent number. Whether service has been effected or not, I do not know. It's respondent number 4, my lord.
Number 4, effective service.
State of Assam. And if your lordship will see the prayer is that degree given by the institution located in Assam is not valid.
Lordship, these facts we've ascertained from the RTI, Lordship. So
No. Anyone appeared for Assam?
No, Lordship, not yet.
Service has been served. They've been served.
Lordship.
Are you sure?
I don't think
so. I'll take instructions.
Service report is only with regard to 7 and 18, Lordship. Not
I assess the court, so we'll know.
Lordship, I'll take instructions, Lordship. I'll obtain those service report, Lordship. Huh?
Stop. Stop. It is also noted that after indicating service on respondents number 7 to 18 has also been filed. As such, notice on all these respondents is complete. Stop.
State of Assam has received, Lordship. Office note shows that. I mean, the report shows that, Lordship. They have received.
Stop. Stop. Next paragraph. The Advocate General, on behalf of Meghalaya, prays for further
2 weeks time, my lord.
affidavit and has apprised this court that the challenge in the challenge petitioner is to the degree, the diploma.
Diploma DLED certificate dated January 2022.
Issued by the state of Assam, which is presented by respondent number 4. Stop. It is also stop. He therefore submits that an affidavit from respondent number 4 will be of absolute necessity in the adjudication of the instant matter. Next paragraph. On hearing submissions, let's stop next. Accordingly, this is matter after 2 weeks to allow for affidavits by the state respondents, respondents number 7 to 18, and also for appearance and for affidavit of respondent number 4.
4, 5, 6, my lord. 4 is state of Assam. 5 is Directorate of State Council Education Assam, and 6 is also Directorate of Elementary.
Been served.
4, 5, 6, my lord. There are 3 respondents.
4, 5, 6. 4, 5, and 6. Last paragraph. Accordingly. Response, private respondent 7 to 18, and also by the state of Assam. Respondent number 4, 5, and 6. Yes. That's item number 20. 23.
23.
Item number 23.
So ready for hearing.
24 is ready.
This is matter together with, that is the first petitions also after 2 weeks.
Obliged, sir.
Okay. That shows the orders. Mr. Dendo, the granary, you're ready to do it today? Because other matters are there, like part heard. This other.
I had raised the issue on the last occasion, whether the report had been placed before the House in view of Section 3(4). They were supposed to.
Commission Inquiry Act.
Yes, of the Act. They were supposed to respond to that only.
Was the report placed for assembly?
That action taken report, my lord.
Not action taken. Section 3.
The report of Justice Vaipai.
That, my lord, the law is that it is not mandatory as such whether to place it or not. But their prayer is, I don't know whether it has been placed or not. If it has been placed, then my friend can inform me. I have no idea because the prayer was the direct CBI inquiry. That was the prayer, my lord. So therefore, that is the only.
That is what we want.
I am concerned with that only, my lord.
Your lordship had raised the query in view of Section 3(4). Whether the
on Section 4, if your lordship will see Section 3 and 4, it is not mandatory for the state government to place the report. But I don't know whether it has been placed or not, my lord.
When do you find out?
Fine, I will find out, my lord. I will find out.
Because 4 says it shall be placed.
Yes.
Because this was subject matter of some judgments also, whether of placing of the report or not, my lord.
Yes, I'll get general place a lot further 2 weeks' time to ascertain as to whether the report, the inquiry report, was placed before the assembly as given in Section 3 and 4 Commissions of Inquiry Act 952, correct?
Yes. Is only what is required under the Act, my lord, is action taken report. I will find out because
whatever action was taken.
Yes, something.
But even the prayer also now, I don't know because there's anyway.
And I have argued, my lord.
Yes.
I'll find out.
Do you have to make replies to Mr. Paul's?
We have to already argued everything. So nothing.
I'll give you 35 minutes.
I have argued almost.
I will try and make it as concise as possible. My only difficulty is, a lot of law has been cited. I would have to rebut
the law
on facts.
The law will follow the facts. Yes.
I will very quickly, start by just taking your lordships to how this matter has emanated.
We'll go lead matter BIA, or should you go with that?
My lord,
R&B carbide.
My lords, my humble submission would be the lead matter would be BIA, because my lords, this is first and point of time, and during currency of this matter, my lords, the subsequent developments happened, and that's when the other matters came to be filed.
Number 4. You take number 4 now. I mean WC number 4.
My lords, these all came, my lords, after the subsequent order was passed. So our, my lords, the grievance in that number 4 was with regard to, my lords, that while this matter is pending before your lordships, my lords, for adjudication, my lords, the new order was given effect to where, my lords, I was required to pay the differential tariff. So, my lords, that in my humble submission would be the, my lords, a subsequent matter. It's an branch of this original matter.
Pick up the hearing matter first.
Item 24, my lords. 35. Item 35, my lords, in my humble submission would be the lead matter.
Yes.
What had happened here is, my lords, by orders dated 5/6/2024 and 6/6/2024, my lords, the tariff and the true-up business for the financial year 2024 to 2026 and 2026 to 2027, that's the true-up, my lords, that was passed.
Yes.
Now, what happened is, my lords, that in between the time the matter was heard and the order was passed, the chairperson, my lords, superannuated, and, my lords, the law member, who was admittedly a member of the part of the quorum, my lords, had signed the order singly. That's where the entire dispute starts. So, my lords, initially 3 writ petitions came to be filed before this Honorable Court, my lords. That's WPC number 216, 217 and 218. These 3 matters came to be filed before this Honorable Court, my lords.
Yes.
And an interim order was passed by this Honorable Court on 25/6/2024, staying those orders. Staying the orders dated 5/6/2024 and 6/6/2024. My lords, against this order of 25/6/2024, an appeal had been preferred by us, my lords, that is the BIA, before the division bench of this Honorable Court. See, with, my lords, liberty to, with permission to file an appeal, because we were not parties to the original proceedings. Now, that matter, my lords, came up subsequently. Before that, my lords, on 23/7/2024, the petitioners, my lords, they sought to withdraw these writ petitions.
Yes.
With liberty to re-agitate the matter before the Commission. This Honorable Court, my lords, makes an observation that this Honorable Court has not gone into the merits of the matter and simply permits the petitioner to withdraw the matter and go before the appropriate Commission for adjudication. My appeal comes up before this, my lords, the division bench on the 31st of July 2024. Leave is granted, my lords, but we withdraw the appeal because by then the writ petition is already withdrawn. Now, my lords, an application is filed under section 62 and 64 of the Electricity Act before the Commission. And that's where, my lords, this entire dispute now starts. So I'll first take your lordships to that application which was filed by the, well, it's respondents herein. Well, it's before that, if your lordships permit me, if I can just take your lordship very quickly to page 21. That is the orders passed by this Honorable Court, because it would have a bearing.
Yes.
My lords have it. This is the order of, my lords, 23rd of July 2024. It says, Mr. So-and-so, Ekumar, learned senior counsel assisted by so-and-so, learned counsel of the petitioner, prays that he may be allowed to withdraw the instant writ petition as a statement has been made by the learned counsel for the respondent number 1, that the matter will be taken up for reconsideration afresh by the Regulatory Commission. Mr. So-and-so, Jindal, learned counsel for the respondent number 1, concurs to the submission made by the learned senior counsel for the petitioner. Prayer is allowed. It is made clear that this court has not gone into the merits of the case. Accordingly, the matter stands closed on withdrawal with liberty to the petitioner to re-agitate the matter afresh before the respondent number 1. So, my lords, simply permit them to withdraw the proceedings. You want to go before an appropriate forum, please go there. The substance of this order, my lords, to my humble understanding, would be limited to only that. Now, my lords, an application is filed before the Commission, and your lordships would find that at page 23. My lords, at page 25, if your lordships kindly have a look at paragraph 6. Now, what is the projection made by, my lords, MEPDCL before the, my lords, PGCL, PTCL and PGCL before the Commission, my lords, but your lordships would find at paragraph 6.
Yes.
Now, they say that it is submitted that a statement was made by the Council of the Commission that the orders dated 5/6/2024 and 6/6/2024 will be taken up for reconsideration afresh by this Honourable Commission. The said statement was duly noted by the Honourable High Court by order dated so-and-so. It is also relevant to mention here that, that the order was passed by the Honourable High Court in the presence of one of the consumers, Barnyard Industries Association. Now, in paragraph 7, they say, my lords, that it is submitted that in view of the statement made on behalf of the Commission, the prayer of the petition and the writ petition was duly accepted and no list survived. In the writ petition, the Honourable High Court, after noting the submissions, closed the writ petition with liberty to re-agitate the matter afresh before this Honourable Commission. To that extent, my lords, no difficulty. Now, my lords would kindly have a look at the order, the prayer. It says, my lords, I'll skip the first part. It says, rehear the petition filed by PGCL for old so-and-so, 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 on so-and-so in terms of the order dated 23/7, passed by the Honorable High Court of Meghalaya in WPC number so-and-so. Now here, my lords, a very subtle twist is put, whereby an impression is sought to be cast before the Honorable Commission that this Honorable Court had, my lords, indeed passed some kind of an effective orders, pursuant to which this application is filed. It's done very subtly, my lords. If your lordships kindly see, re-hear the petition filed by so-and-so for approval of the aggregate revenue requirement for 4th so-and-so power generation company for old plants at Sonapani so-and-so, Umtru project at Lakro, mini HEP so-and-so on 29/11/2023 in terms of the orders dated 23/7/2024 passed by the Honorable High Court of Meghalaya in WPC number so-and-so.
Okay, yes.
So, that's where we are at. Now, thereafter, my lords, what has happened is, we file our, my lords, in the meantime, a notice is put up for hearing of these applications. Now, my lords, I would miss, my lords. Prayer number 2 is very relevant, my lords. My lords may kindly have a look. It says, recall the order dated 6/6/2024, passed by the Honorable Commission in case number 3 of 2023. So, my lords, the essential prayer here is to recall an order which has been passed. Now, what I had argued, my lords, at the initial stage before this Honorable Court is, your lordships in these proceedings will also examine whether that power of recall is available with the Commission or not. Now, thereafter, my lords, notices were issued, and since notices were issued, my lords, on certain issues, we came again before this Honorable Court. And, my lords, that was registered as WPC number 274 of 2024. Your lordships would find the order at page 89.
274.
My lords.
At page
89, my lords. 89.
Yes.
My lords have page 89.
Yes.
So this is the order that's passed, my lords. Mr. So-and-so, learned counsel for the respondent today has come with instructions and submits that the notice dated so-and-so issued by the secretary is not a suo motu action.
Yes.
Now, my lords, I would urge my lords to kindly take note of this submission made by the Commission. Is not a suo motu action, but has been made on the basis of applications filed by 3 companies, so-and-so, so-and-so, and so-and-so. Mr. So-and-so, learned counsel, assisted by so-and-so, for the petitioner submits that in this event, the matter can be disposed of by giving liberty to the writ petitioner to raise whatever objections as deemed necessary before the regulatory commission on the next date. In view of the situation as it pertains, the matter stands closed. However, giving liberty to the writ petitioner to raise whatever objection as may be advised, which would be looked into and disposed by the regulatory commission. Matter stands disposed.
Yes.
So, my lords, thereafter, I go before the regulatory commission, my lords. I file my detailed objections on these 3 applications. Now, all these 3, my lords, then come to be disposed of by a common order that is passed by the commission. And that order is, my lords, I'll just give the relevant page number. At page 136, my lords, is that order. I'm sorry, this is the synopsis. I'll just give the exact page. My lords would find that at page 150. NXJ 11, 150.
That's impugn order.
My lords.
Yes, there's 2 days important, 23/8.
I'm sorry, my lord.
The first order, which was signed by a single member, was dated
5th and 6th of June, 2024.
And this recall orders 23rd.
23rd of, my lords, 8.
23/8, yes.
23/8, August 2024.
Yes.
Now, what is interesting is, my lords, now, and that is again a new twist to this entire matter, is that the original order, my lords, was passed by 1 member, admittedly.
And he's part of this quorum again in this new order.
That's one part of it, my lords.
Yeah.
The other part of it is, an order, my lords, passed by a single member is now recalled by two people.
Yes.
And your lordships would kindly appreciate why I say this, because I will try and buttress it. That even if we have to go, my lords, on the question of if somebody has the authority to or the power to do something, he also has the authority to undo that. In that circumstances, my lords, if at all a recall order had to be passed, it had to be passed by a single member saying that I did not have the authority.
Okay, that's the contention.
It cannot be a case, my lords, that one member passes an order, an application is filed, and then subsequently two people decide that no. I'll come to that. Now, the operative portion of these orders, or this order is, my lords, at page 182. My lords, what do they say? 62, para 62 at page 182, my lords. They say, based on the submissions made by the parties, the judgments of the Honorable Aptal, various other judgments of the High Court and the Supreme Court as quoted above in regard to the question and matter, and in line with the provisions of the COB, the Commissions pronounce that a patent error has transpired in issuing the orders dated 5/6/2024 and 6/6/2024. It is appropriate to withdraw the order dated 5/6/2024 and 6/6/24 and hear the matter afresh. The dates of rehearing shall be announced through separate notification. Now, this is where this matter ends, my lords. Now, after this matter ends, my lords, there is a hearing that is conducted and a separate order is passed, which is sought to be enforced subsequently by MECL by raising bills. That comes to be challenged in the subsequent writ petitions that are there before your lordships in the other matters. I think that those matters have been argued at length, my lords, by my learned senior colleague, Mr. Tiwari.
This was also one of the prayer, my lord. Both the prayers were there. Prayer of setting aside the order of
Could be.
My friend, both prayers are there.
Could be.
Both prayers are there.
Could be. I'm not disputing it. Insofar as the matters where we are appearing, my lords.
150, my lord. 150 order was also under challenge in those petitions.
Insofar as, my lords, item
23rd August 2024 order was also under challenge in those petitions.
Insofar as I am concerned, my lords, item number 12, 13, 14, 15, 16 and 17, this prayer is not there. They had made a common writ petition where both those two prayers were there. So that's my given impression of whatever transpired before this honorable court. Now, your lordships would want to first hear me on the issue of maintainability, because the issue of maintainability has been raised by both the commission as well as the respondents.
No, yeah, I mean, actually, maintainability part has been gone, like the quorum and this, all those things have been gone into. The only thing is that this court's concern, you can supplement the arguments which have been, because Mr. Tiwari was very exhaustive.
He was, my lords. I've taken the.
He has exhausted also.
that puts me in both places, my lords. It puts me on a sticky wicket at the same time makes my job a little easier.
Exactly.
Because he's committed on certain parts, my lords, where it puts me in a little difficulty. I must confess. Your lordships would better appreciate that, my lords. It's put me in a little difficulty by
that is why
certain arguments.
If we can supplement, or like.
My lords, I would continue to submit, my lords, that I would stand independent of whatever has been argued.
You want to make your own, plow your own furrow, like that.
For obvious reasons, my lords. For obvious reasons. Because that puts me in a little difficulty because this matter, my lords, what happened essentially is when that matter came to be filed and argued before your lordships, the entire, if I may put it, my lords, the entire dish was ready. I was here before your lordships at the very initial stage, so there's a very limited challenge that is there. And your lordships had kept this matter pending only on this issue, my lords, that regarding whether the jurisdiction is available or not available, that's the only thing on which this matter stands. So if this goes, my lords, everything else goes in my humble submission, irrespective of everything else. Because
you make your submissions.
My lords.
So you don't want to.
But only one, your lordship, kindly see the prayer at page 26. Prayer at page 26. Oh, sorry. No, sorry. The prayer is, my lord.
My prayer was at page 13.
13, my lord.
Here it is restricted only to the prayer.
The thing is that when this was filed and the other
and he participated in subsequent hearing also.
That is
and
without
the order was
prejudice.
where is that or without
We have
prejudice?
filed our application, my lord. It says without prejudice.
So your lordship your lordship has already heard so far as the jurisdictional aspect is concerned, my lord. In detail.
But Mr.
Paul wants to supplement something.
Insisting on like making his own.
No. I am only, my lord, because there are two difficulties there, and I must be candid. And your lordships have heard the matter, so your lordships are aware. There, my lords, it's a joint challenge. There's a common challenge to two orders that have been passed.
Yes.
So, my lords, one of the difficulties and one of the arguments that have been raised by both the Commission and the MECL is that the plea of alternative remedy. That, my lords, in this case would be a little different because here it is only restricted to that first order of recall. The tariff order, my lords, is not under challenge in these proceedings. The other aspect is, my lords, your lordships will kindly appreciate the foundation for even that writ petition is this writ petition.
Yes.
Because what is pleaded over there is also, my lords, that your lordships are seized of this matter, where orders have been passed, affidavits have been exchanged, and your lordships had fixed the matter for hearing. In the meantime, that order came to be passed.
Okay.
So that's why, my lords, I humbly submit that we're on a slightly different footing than what has been argued in that original matter. Of course, the substance of it would be the same, my lords. It would not be of much difference. My lords, I will take your lordship straight to the written objections that have been filed by both the MEPDCL and the Commission.
Where's Mr. Jindal?
I think Mr. Venkatesh is appearing for the. Are those objections?
Please, my lords. I am appearing on behalf of the Commission, my lord.
Okay.
I am assisting my lord, Mr. Venkatesh only.
Right. Okay.
So he will be joining my lords very shortly, my lords.
Well, it's, if my lords kindly have the objections that have been filed by the Commission. As a matter of fact, they filed this written argument is actually filed in WPC number 339.
Yes.
If my lords have the written objection filed by the Commission, my lords.
Yes. Counter affidavit.
No. They filed a written arguments. Well, it's written submissions. They call it written submissions on behalf of respondent number 1.
Today?
It has been filed on 17/3/2025, my lords. That's what my copy says.
Okay, yes. We just got it just now.
My lords, if I may please submit, my lords. On the last date of my lords.
Yes. So I had taken the liberty of summarizing my arguments in a written format, just for your lordship's convenience, because your lordship heard us over a span of days.
Right.
Since, my lords, the arguments were at length, my lords, I would restrict myself only to this document because I've heard what my learned friend has already argued. I think it covers everything that he's argued.
I'll take leave for 5 minutes.
Well, if I may just draw your lordship straight to paragraph 2.
Yes.
In the impugned order, the Respondent Commission has inter alia held that the order dated so-and-so and so-and-so earlier passed by the Respondent Commission can be recalled and reheard by the Respondent Commission by invoking its inherent power.
Yes.
My lords, impugned order, paragraph 61, page 182. Now they say, pertinently, BIA has essentially argued that the Respondent Commission does not have the inherent powers to recall and rehear its own orders, and hence, the impugned order is liable to be set aside. Further, it has also been argued that the Respondent Commission has become functus officio, having once passed the said orders, so-and-so. Accordingly, petitioner has preferred the present writ petition. But let's then the submission. It is humbly submitted that the impugned orders have been passed in accordance with law in accordance with the Indian Electricity Act. The order dated so-and-so were not signed as per law. My lords, I'll skip this part. We can come back to this. B, my lords, is relevant insofar as this power, the exercise of power is concerned. A Respondent Commission has inherent power to review, recall its orders. It is submitted that the Respondent Commission has inherent powers under regulation so-and-so. Further, the tariff proceedings were undertaken in pursuance of the so-and-so. Notably, regulation so-and-so of regulations also grants inherent powers to the Respondent Commission to make such orders as may be necessary to meet the ends of justice. It is settled law that a court or tribunal is invested with such ancillary or incidental powers as may be necessary to discharge its functions effectively for the purposes of doing justice between the parties, and in the absence of a statutory prohibition, in an appropriate case, it can recall its orders in exercise of such ancillary or incidental powers. My lords, an authority has been cited. That's the Greater Noida case. In Greater Noida, my lords, I'll skip. Similarly, in the present case, the Respondent Commission has inherent powers to recall and rehear its own order, considering the earlier orders were not signed in terms of the extant law. In addition to the aforesaid, the Honorable Supreme Court in so-and-so has held that a tribunal or a court may recall an order earlier made by the proceedings culminating into an order suffer from inherent lack of jurisdiction, and such lack of jurisdiction is patent. Further, the power jurisdiction of the Respondent Commission to recall its orders can also be traced to the inherent powers of the court to undertake procedural review when the order suffers from procedural illegality, which goes to the root of the matter. In the present case, considering that the earlier order suffered from procedural error, non-signing by the members, the order can be recalled and reviewed by the Respondent Commission, invoking its inherent power. Moreover, reliance has also been placed by the settled law that in the absence of a specific provision in the statute, the inherent power of the court can come to its aid and act ex debitio justice for doing real and substantial justice between the parties. In this regard, reliance is placed on so-and-so. Considering there was no express provisions under COB regulations that to allow Respondent Commission to recall its order, the querist can resort to its inherent power considering that the earlier order is non-est. So, my lords, if I can sum up the arguments raised is, the Commission is saying that I have exercised my inherent power to recall that order. That's one. Number two, my lords, in paragraph 13 they say, my lords, the order can be recalled if it suffers from inherent lack of jurisdiction, which is palpable. And my lords, number three, they say at para 17, considering that there is no express provisions under the COB regulations that allow the Respondent Commission to recall its order, the querist can resort to its inherent powers considering so-and-so. So there is an admission by the Commission that the regulations are silent insofar as recall is concerned. So these three parameters, my lords, are falling straight from the Commission. First, my lords, that it is in exercise of inherent powers.
Yes.
Second, my lords, that inherent power can be exercised only when there is lack of jurisdiction, which is palpable.
Yes.
And three, my lords, there is an admission by the Commission that in para 17 that the regulations are silent insofar as recall is concerned, and hence, my lords, resort can be taken to inherent powers.
Yes.
Now, my lords, my answer to all this is just one order that is passed by my lords, and I have taken your lords, my lords, to that order. My lords, in my second round of litigation, had passed a specific directions asking the Commission to revert back to this Honorable Court, saying that what is the power you are exercising. Commission reverts back to this Honorable Court saying that I am not invoking my inherent powers. It is the application of MEPGCL, MEPDCL and MEPTCL that I am now hearing these applications. Having done that, in my humble submission, the Commission can now not take a U-turn and say that I have exercised my inherent powers. That door is closed insofar as the Commission is concerned.
Yes.
So the entire argument of inherent powers or availability of inherent powers with the Commission or not available, my lords, goes. And my lords, for that I will just again take your lordships back to that order that has been passed at page 134. This is passed in WPC number 274, my lords. Date of the order is 8/8/2024.
WPC number?
WPC number, my lords, 274 of 2024. My lords, it's there, it's next, at page 133.
Of this?
Yes, my lords. I had made a passing reference to this, my lords, when I had started my argument.
Right.
At page 134, my lords, we will kindly see Mr. S. Jindal, Learned Counsel for the respondents, today has come with instructions and submits that the notice dated 2/8/2024 issued by the Secretary, State Electricity Regulatory Commission is not a suo motu action but has been made on the basis of applications filed by companies MEPDCL, MEPGCL and MEPTCL.
Yes.
So once, my lords, you have committed saying that no, this is not my inherent power, I am not doing anything. I stick to my position, my lords, that that order is correct. Somebody comes and one of the aggrieved parties comes and files an application before me and I'm hearing it. Now, that would then bring me to the second limb of my argument, my lords, which is the foundation of which is laid by the arguments made by my learned friend at paragraph 17. Of that written argument, my lords, which I pointed out before, your lordships, that there is an admission on the behalf of the commission, my lords, that the guidelines or the, my lords, the regulations are silent insofar as recall is concerned. So there is no statutory provision insofar as regulations are concerned. Recall is concerned in the regulations. That power is not available.
Yes.
So once, my lords, what I am humbly submitting before your lordships,
yes,
that you are acting on an application which your own regulations are absolutely silent on. And it is admitted by you that my regulations are silent. So that brings, my lords, to the fore a very pertinent question, that whether a tribunal, which is the creation of a statute, can exercise some power which is not given expressly to it under the statute.
Okay.
My humble submission will be, my lords, it is in the negative. A court can have inherent powers, my lords. A commission or a tribunal, which is the creation of a statute, has to exercise its powers within the four corners of the statute that creates it. If a certain power is not available with you, that power is not available.
Okay.
You cannot invest upon yourself a power saying that, oh, I have that power. So, my lords, in the first place, that particular application filed by MEPGCL could not have been heard by the commission. Now, the statute makes a, my lords, provision for review. I must assist this honorable court, my lords. There is a provision for review. And I'll take my lords through the relevant provisions of the regulations. The admitted position is no application seeking review has been filed till today. And which is why, my lords, I had pointed out in the second paragraph of the application filed by the, my lords, corporation, I'll just jointly refer to them as corporation, the expression used is recall.
Yes.
First prayer is rehear, second prayer is recall. Now, my lords, I must take your lordships to what does the commission have to say with this? My lords would find that at page 176 because this was argued before the commission as well. At page 176, my lords, your lordships would see there's an issue framed to that effect. Whether the commission can recall the orders issued as above and rehear the petitions afresh. It is necessary to note that the issue of power jurisdiction of courts or tribunal to recall their orders is no more res integra, and the law has been settled by a catena of judgments passed by the Honorable Supreme Court. It is now settled that a court or tribunal is invested with such ancillary or incidental powers as may be necessary to discharge its functions effectively for the purposes of doing justice between the parties, and in the absence of a statutory prohibition in the appropriate case, it can recall its order in exercise of such ancillary or incidental powers. In this regard, reliance is placed on Greater Noida, the Noida case, my lords. But Noida is essentially on the foundation of inherent power. in Greater Noida, issue before Honorable Supreme Court is whether NCLT order, whereby NCLT had refused to recall its order, was correct. One of the issues framed by the Honorable Supreme Court was NCLT has the power to recall its order. While deciding the issue, holding that NCLT had powers to recall its orders, the Supreme Court dealt with Rule 11 of so-and-so, which is reproduced. Nothing in this rule shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the ends of justice or prevent abuse of the tribunal. After noting various judgments passed on the issue, the Honorable Supreme Court concluded as thus, my lords, I'll skip this. Therefore, it emerges that the Honorable Supreme Court upheld the powers of NCLT to recall its orders inter-alia on the basis of the following factors. Ordinarily, courts tribunals have the power to recall their orders. NCLT's powers is recalled as preserved in rule so-and-so. Order of recall can be passed inter alia if the order is without jurisdiction. On a juxtaposition of the findings of the Honorable Supreme Court with regard to the present set of facts, following crystallizes, the Commission has inherent powers under COB regulation, where Regulation 26 states as follows. Nothing in these regulations shall be construed as barring the Commission from exercising its powers under the Act, for which provisions have not been made or have been made inadequately in order to subserve the spirit of the Act. Now, the language here is, my lords, very different. And I'll read it slowly, my lords. Nothing in these regulations shall be construed as barring the Commission from exercising its power under the Act, for which provisions have not been made or have been made inadequately in order to subserve the spirit of the Act. In other words, my lords, what it says is, if your regulations do not provide for something which is provided for under the Act, that power is saved.
Yes.
It is distinct from what Regulation 11 of the NCLT Act is. It does not give you any independent power.
Yes.
If I may read it again, my lords. Nothing in these regulations shall be construed as barring the Commission from exercising its power under the Act, for which provisions have not been made or have been made inadequately. So provisions, my lords, there is a provision under the Act. Your regulations may not be, my lords, in sync with the Act or may be inadequate with the Act. To that extent, to subserve the spirit of the Act, my lords, you have the power. Now, this is distinct from 11, my lords, which I will read for everybody's convenience, my lords, at paragraph 57 at 177. My lords will kindly have a look. It says, nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the ends of justice or prevent abuse of the process of the tribunal.
Yes.
Now, this is a wide, well, it's almost similar to what is there in.
What he's saying, it's observed that's only within the four corners of the Act.
What I originally submitted, my lords, when you are a creation of a statute,
so within four
your
corners,
existence is within the four corners of the statute.
Any like lacuna or something has been filled up.
Because this would be a case of delegated legislation, my lords. This would be a case of delegated legislation. So, my lords, if your legislation is incoherent, my lords, or at a certain place, my lords, inadequate with regard to the provisions of the Parent Act, merely because your regulations do not have that power, my lords, that does not mean to subserve the purposes of the Act, my lords, you will have the power. That is different from inherent powers. Inherent powers would be something, my lords, like 151 of the CPC, which, my lords, in some light has
an enabling provision.
It is only an enabling provision. So, my lords, which is why in paragraph 17 of the written arguments filed before this Honorable Court, the Commission admits that yes, we do not have the power of recall.
Okay, yes, that's noted.
So, my lords, the foundation on which this order is passed is on an absolutely wrong premise. And therefore, my lords, it is an appropriate case which has to be decided by this Honorable Court only. I cannot go to APTEL. Because now, as your lordships have seen, it is a case of jurisdiction. It is a case where the Commission, my lords, usurps jurisdiction unto itself and says, no, I have the power.
Yes.
And your lordships will kindly see how it takes a U-turn. Initially, it says, no, I'm not exercising my suo motu powers, it is on the basis of an application. Now, when the matter opens up, my lords, I say, no, it is my inherent power. I made a mistake, so I'm correcting it.
Okay.
The purpose of this order, my lords, your lordships will see at paragraph 62, where they say, my lords, a patent error has transpired in issuing the orders dated 5/6/2024 and 6/6/24. At paragraph 62 at 182.
Yes.
So it says, my lords, I have made a mistake, I'm correcting it. In exercise of my inherent power. And in the written submission, it says, my lords, that there is no power of recall otherwise available to me. So by no stretch of imagination, my lords, we can say that regulation my lords, I'm sorry. My lords, regulation 26 of the COB regulations, my lords, can be said to have deemed any or invest any inherent powers on the commission. That power is not available to you. So in the absence of any such power, my lords,
so they can't even review an order.
They have the power of review.
They say, okay, sorry. They cannot re-examine an order which is, patently illegal. I mean, on the front of it, because as per the quorum. Now that is the thing.
My lords, if that were to be my lords, which is why I started my lords, which is why I started off my argument in the first place, that whether it is a power you are independently exercising, or whether it is a power you are exercising on the basis of some application filed before.
Right. But they can't. So according to you, there's a question regarding the scope. Once your hands are tied,
that is why, my lords, I take the argument of functus officio.
Your hands are tied. So you can only within the four corners of that.
It is within the four corners of the statute that you have to.
No inherent powers, only an application has been filed. That's it.
That's it.
Okay.
And you say, my lords, you say that it's not my inherent powers. I have not done it independently. It was a separate issue, my lords, that once the constitution of the commission comes into its entirety, commission says, no, that order is wrong. We recall it and we will hear it afresh. That's not the case. Applications are filed. Your lordships ask them for instructions. Please tell us, what power are you exercising? Yeah. So you make a categorical submission. I am examining their applications. And therefore, my lords, what I had...
That's on record, yes.
And therefore, my lords, that has to be looked into with what I had also submitted, that the order was originally signed by the law member. The subsequent recall order, interestingly, is now signed by two people. What they would try and probably say is, my lords, that the constitution of the commission is the two persons, and therefore the commission has passed the order. It is not Mr. A or Mr. B. That is exactly my argument. It is the commission which passes the order. It is not Mr. A or Mr. B.
So that makes it valid, you see.
I take that, my lords, and I turned it around. I said that if that is your argument, then my order of 4th, 5th and 6th of June become valid in law.
And we'll continue. Second half.
Well, may I request, my lords, if it is not inconvenient to everybody, could we have it tomorrow, my lords?
No, tomorrow I'll score with it because...
I'm sorry, my lords, tomorrow there's some difficulty. I'm informed. Well, would it be inconvenient day after tomorrow, my lords?
See, you're turning the whole thing on his head now.
I'm trying to.
Again, red herring. Again, my lord, I will say red herring.
I was in the, firm belief that, it'll be just a perfunctory hearing, you'll supplement it. But then if you're turning it in,
different
Mr. Tiwari might raise his arms and come up again. That is it.
My lords, with all due respect, but what had happened is prior to my difficulty, me and Mr. Tiwari had a discussion, my lords, where we decided that this part I'll handle, that part you handle. Of course, my lords, I came into some difficulty and
of course, I mean that is why we could have, but he said I'm ready, so
I don't think, my lords, he went into the finer detail of. That is why I said, my lords, I'll have to get into the finer detail.
We can't say finest detail. He went into the.
I'm sure, my lords, he's senior to me.
The job is to make a lordship's life difficult. Ultimately, lordship will decide the matter. That's our job.
Right thereafter.
I'm okay.
I'm